Court calls the second case this morning, 128014, Branden Williams versus Barbara Greenstein and Nicholas Anderson, appellants. I'll take your appearances when you're ready, please, for appellant.
Don Peterson for the appellants.
Thank you.
May it please the court, Richard W. Martin for appellee.
Thank you, counsel. Appellant, you may begin, and let me know if you'd like some rebuttal time.
I would, probably 3 minutes.
Very good. You may.
Thank you. So this is a case involving the Kansas Public Speech Protection Act. I represent Barbara Greenstein and her daughter, Nichole Anderson. Nichole had a child with the plaintiff, Mr. Williams. The child is about 7 now, I believe. Mr. Williams, in 2021, had a series of DUI charges. And he sometimes drives the child when he has custody. And so Barbara Greenstein was concerned that the child might be at risk. These DUIs are a matter of public record, the disposition of those cases. The first case happened and was resolved in April of 2021 here in Sedgwick County. It resulted in a guilty plea and probation. About 3 months later, there was a Coffee County case. And the paperwork on that said it was a first offense, and that case was resolved by way of a diversion. And there's a journal entry on that. And then there was an Iowa case about 4 months later that involved a guilty plea with a deferred judgment. So Barbara Greenstein gathered those records and wanted to make sure that the Sedgwick County court was aware, because it appeared that these individual courts were not aware of the other cases. And so she just thought, you know, they ought to at least know about this history and how that's happening, and it may or may not be a probation violation, but they should know. So she sent an email to the probation officer in the Sedgwick County case, and it attached these journal entries from the Coffee County case and the Iowa case.
Did it say that he'd been convicted in those cases?
No, it didn't. And I don't know that it would matter if it did, because it attached them. She's not a lawyer. And the probation officer is going to do whatever they want to do and make their own evaluation of the significance of those. But it did not say that. And I appreciate your question, because the petition that was filed below, this is a defamation case that Mr. Williams filed. The petition that was filed was based on an affidavit that Mr. Williams attached. And the affidavit says that her email claimed he'd been convicted. And in response to this appeal, and I'll talk procedurally about how we're here, but that position is continued in the briefing, that the defamation is that she said he was convicted. Well, the word convicted is not in her email. But again, I think that's splitting hairs. I mean, she's not a lawyer. No probation officer is going to be relying on her description of these journal entries which were attached, okay? So let's talk about the Kansas Act, the Kansas Public Speech Protection Act, and that's the last time I'm going to say that, because I'm just going to call it the Act from now on.
Thank you.
That was passed to give some teeth and deter meritless retaliatory defamation cases. And it provides some special procedural tools. It allows for a motion to strike, and once a prima facie claim under the motion is established that lawsuit was filed essentially in retaliation for a protected form of speech, the burden immediately shifts to the plaintiff in the case to show a likelihood that they will win, okay? Below, we never got to the likelihood of win. We never even really got to the prima facie, strictly speaking, component. The lower court found that the communication here, the email, was not a protected form of speech at all. And so none of the other analysis was made.
And to the district court, did you argue both the free speech and the right to petition as protected
Yes.
forms of, okay.
Yes, and the analysis is probably is a little separate and different. But most of the arguments that are being made are more global anyhow. It seems to me.
I was going to ask which you think is your stronger argument, but you're lumping them together.
Well, I do. I mean, I think it's probably best characterized as petitioning. The email is indeed motivated by concern for her granddaughter. But it's not only that. I mean, it's a matter of public concern. Drunk driving is an issue that a lot of people care about. And so, and the public obviously has an interest in reducing drunk driving. So,
do we have any cases that really talk about that in the free speech context in this act of how much public interest? Is it enough that you have just some public interest? Does it have to be majority? Is there some test we can apply?
I don't think we do. I'll say this, that if you look just from a statutory construction standpoint, if you look at the act itself, it has in subsection B, it describes the purpose. And I'll acknowledge that the purpose says that, constitutionally protected speech that is in connection with a public issue or an issue of public interest is to be protected to the maximum extent, okay? But I think the crafters of this act intentionally made its mechanism broader than that purpose because they wanted it protected. And so you don't make the boundaries of the act limited just to when it's truly a matter of pure public concern. To protect that, you make it even broader. And so if you look at the language of the act, as opposed to the purpose section, okay? If you look at the language, so in the definitions, it defines what is petitioning. The exercise of the right to petition is found in subsection C5. And it has a litany of things, a communication in or pertaining to a judicial proceeding. And so that's one of the ways I think we meet the petitioning component here. The email refers to a judicial proceeding, multiple judicial proceedings. And so we think it fits that very first item under a communication pertaining to, okay? But there's a catch-all at the end. Subsection E, any other communication or conduct that falls within the protection of the right to petition the government under the Constitution of the United States. Well, if you look at the law on that, I don't have to be public concern. I've cited you cases on that. There's a Gorsuch opinion from the 10th Circuit explicitly holding that it doesn't have to be a matter of public concern for me to be protected when I'm petitioning. It can be a purely private matter. This is the Van Deen case. And at the very beginning, they sum up their holding early on in the case. They say, we write today to reaffirm that the constitutionality enumerated right of a private citizen to petition the government for the redress of grievances does not pick and choose its causes, but extends to matters great and small, public and private. Whatever the public significance or merit of Mr. Van Deen's petitions, they enjoy the protections of the First Amendment. This was a purely tax matter. He was upset that the tax body was retaliating against his appeal of his tax claim. There was no public interest in that case. And the lower court threw it out and said, you don't have a First Amendment protection to your petition. And the 10th Circuit said, yes, you do, even though it's purely private. So that subsection E, when it says anything that's protected, as a matter of petitioning the government by the Constitution means we don't have to show any public concern. Now, we can. I think this is a matter of public concern. But this debate that we have to somehow show public concern because the purpose section had some language in there about public, that's the purpose. But the mechanism is broader precisely to make sure that purpose is protected.
And that's what the district court was concerned about. There wasn't any public.
That's
He saw this as simply a retaliatory move on grandma's part or something.
Right, that's exactly right. And that's just mistaken. Fundamentally, that's the error here. But I also do think it fits the first category there of being about a judicial proceeding. And we cited you the cases that talk about, reporting a crime is a protected activity. The response that's been made is primarily that, well, but you weren't reporting a crime. I don't know. I mean, I think it could be described that way. These are other crimes that Sedgwick County folks weren't aware of. Were they convictions or not? Who knows? But this information is, I'm presenting this to you for whatever you seek to do with it. And it seems to me that that's a communication about a judicial proceeding to an officer in another judicial proceeding. And that's clearly, the connection doesn't have to be that strong if you look at the language of the Act. A communication in or pertaining to. So it doesn't have to be in the proceeding. It doesn't have to be testimony from the witness stand, right? It can be about the judicial proceeding, which is exactly what the email was about. So the consequence is we filed a motion to strike on the basis that this lawsuit was filed basically because of or in retaliation for the email. That element, I don't think, would even be disputed. I mean, the petition itself references this, so it's clearly in response to the email because the petition specifically refers to it and then misdescribes it by saying it said that there was a conviction. And so the next step would be a determination as to whether there's a likelihood of success. We never got to that below. I mean,
If you win, we need to remand for that determination.
I suppose so. I mean, there are so many problems with the nature of this claim, not the least of which is a causation problem. I mean, how is she responsible for whatever decision that the court officer chooses to make based on this new information? That's obviously a free, uninfluenced determination by a professional based on information from a layperson. So how she could be responsible for whatever decision they make is beyond me. But that's one of many problems fundamentally with this case. But I think I agree with you. It wouldn't be appropriate for you to take that up. It needs to be a remand. An important part of this act is an attorney fee shift. Now,
Let me just say you're getting into your rebuttal time. If you
okay,
would like
and
to, you
so
may.
we will be, seeking some sort of determination on the fee question. I'll file a petition for fees, but whether what happens now technically meets the definition or not, I think the purpose of the act, whether determined here for fees on the appeal or below, there should be clarity to the lower court whether they're supposed to include the appellate fees if we prevail. Thank you.
Thank you, counsel.
May it please the court?
Counsel?
Thank you. Well, I'll start off by saying that I think that Judge Goddard's got this right at the district court, that this is not a matter of public concern.
Does it need to be?
It does, because the act defines the exercise of free speech as including a matter of public concern. So
What about his right to petition argument?
well, I don't think it was, I don't think Ms. Greenstein was, Greenstein was petitioning anyone. I think that, as Judge Goddard's put it, that the case doesn't morph into one of public concern merely because she communicated to a probation officer. She said that this is a private concern for her granddaughter. You're right, she didn't say convicted exactly, but she did say in that email that the defendant has repeatedly violated the terms of his probation. And that is the purpose for which she sent it. Mr. Williams' allegation in his complaint is that, and this is supported in his affidavit that was attached in opposition to the motion to strike in the district court, that Ms. Anderson, who's the defendant in this co-defendant in the civil case, used the fact of an arrest warrant being out to get a leg up in the custody dispute that was pending in Riley County, Kansas. And in fact, that's what happened. And my client's parenting time, as a direct result of that, was restricted because of this arrest warrant.
But we don't determine private or public or intent from the damages that flow from that, do we, as far as this act is concerned?
No, but I think it shores up the notion that Ms. Greenstein's concern was not as a disinterested citizen making a commentary on a matter of public concern, but rather she had a direct interest in influencing, along with her daughter, the course of the custody dispute.
So it could be a bit of both. She definitely had a personal interest in making sure this probation officer knew about these other DUIs, but there is also a public interest in making sure that DUI offenders are not, that drunks are out driving on the road.
Well, I don't think that's borne out in the record that that was Ms. Greenstein's concern at all.
Well, I've read her, the only statement of her intent as to, I've read what she sent, and there is a statement in here of her affidavit about what her intent was, so that is in the record. But all of this goes to the free speech aspect, where there does need to be some public concern. And you would agree, I think, with counsel that Kansas, under this act, has not established a test, correct?
I agree with that, Your Honor.
Okay. And I would like you to focus on the right to petition, because to me, his argument today is somewhat convincing, that the Van Deen case and others, if you're petitioning the government, that in and of itself is a protected act. I mean, you would admit it was a communication from Ms. Greenstein, correct?
Yes.
Okay. To a public officer, correct?
A probation officer, maybe. I don't know.
Well, and at any rate, and the way that the right to petition is defined in the act does not seem to include the requirement that it be on a matter of public interest, correct?
That I don't know, and I didn't pick that up from the briefing, so I just haven't looked at it.
Okay.
I saw that there was a lot of qualified immunity cases that talked about First Amendment concerns, but no, I didn't pick up that argument from the briefing.
That's fine. Go ahead.
But even if this matter could be construed, this communication, as a petition for redress, it doesn't give Ms. Greenstein the right to make false statements. And so a false and defamatory statement, as we know, can be the meaning can be inferred from the context.
Well, I'm looking at her email. What in it do you claim is false?
Well, I think with the surrounding circumstances, it leads one to believe that my client was convicted, which obviously the prosecutor thought so, because in his motion to lift stay, which is, I take as a motion to revoke probation, the motion itself says that Mr. Williams was convicted in Washington County, Iowa, of a DUI. And we have provided in Mr. Williams' affidavit, Exhibit 2, which is a letter from the Washington County prosecutors, clarifying, saying that the point of this communication is to clarify that under Iowa law, this is not a conviction, and that was to the Kansas Department of Revenue, because it is different. Ms. Greenstein said in her communication that Mr. Williams has repeatedly violated the terms of his probation, and that was a false statement. It, I think, caused the prosecutor to file a motion to lift the stay and revoke probation that he later withdrew, because he was under the impression that this was a conviction, I think as a direct result, and I think discovery will bear this out, as a direct result of Ms. Greenstein's communication. That was the very purpose for which she sent it. So this is anti-SLAPP legislation, and I think Ms. Greenstein is attempting to avail herself of that because this isn't a SLAPP suit. This is not, my client isn't a bully trying to shut down free speech or redress of any kind. He's not using this litigation as a pretext to do that. He has claims because he was damaged as a direct result under common law of Ms. Greenstein's misleading communication. And that's all we're here to do, is determine whether she's entitled to that immunity. We submit she isn't. She's just not.
Thank you, counsel.
Thank you, Your
You have 3 minutes.
Thank you. Well, let me first address the question of whether the act itself requires that one who's petitioning be petitioning about a matter of public concern. So the operative language is found in subsection D of the act. And the language, it's a long paragraph, but the key language is actually the first sentence, and it's pretty brief, so I'll just read it. A party may bring a motion to strike the claim if a claim is based on, relates to, or is in response to a party's exercise of the right of free speech, right to petition, or right of association. And then it goes on to describe the various burdens of the parties. So that's what the motion was about. Did she exercise the right to petition? And as I told you before, the act defines the right to petition broadly to include any other communication or conduct that falls within the protection of the right to petition the government under the United States Constitution. The statute as written does not require us to prove that this was a matter of public concern. It just doesn't. But even if it did, I don't know how drunk driving is not a matter of public concern. The huge irony of this case is that this is a defamation case brought by Mr. Williams, alleging that my client made a false statement to a court officer, when in fact she didn't.
But that doesn't matter at this point of the game, does it? The falsity or truth is not part of what we're looking at under the act right now.
I suppose, but I just think it's ironic that this whole case is based on a statement from his affidavit. I mean, it's quoted on page 4 of their brief. She told the authorities in Coffee County, Kansas, that plaintiff was convicted of DUI in the state of Iowa. It's just not true. That's the irony of this case. I mean, the underlying claim being made is flatly false. And yet, at worst, my client did not describe as well as a lawyer would as a layperson a journal entry. To me, it boggles the mind, but in any event, I agree with you, it probably doesn't really matter for purposes of this appeal. Look, in sum, the whole point of the SLAPP statute is that it's easy to file a defamation case and to bog somebody down in discovery and make them spend money. And it turns out, despite this simple procedure where a judge can look at it very early and evaluate, does this person have a probability of winning? We weren't able to do that. We're up here on an appeal. So I don't think the purpose of the statute's really been met, but I would invite you to provide a little more guidance. You know, I think our case law needs that. But it, in my judgment, will be very, very helpful to provide the same clarity that now Justice Gorsuch provided in the Van Dien case here, and make it clear that even though the purpose language of this act says, you know, makes reference to public concern, that is not in the operative part of the statute, and that's probably by design, because if that's your goal, you don't put the, if you want to really protect that, you put the boundary a little farther out to make sure it gets protected, which is what the legislature did. And so we meet the operative language of the statute. The court was erred in requiring us to show public interest. Plus, I think it is a matter of public interest, but in any event, if you want to go ahead and chime in on is drunk driving a matter of public interest, I would invite that as well. But in any event, we would, for all of these reasons, request a reversal and remand. And a little instruction on how to handle the attorney fee piece would be helpful too if you think it appropriate. Thank you.
Thank you, counsel. We appreciate the arguments by both counsel. We'll take the case under advisement.